afternoon, and welcome to the fourth and final panel of the 2020 Lee E. Teitelbaum Utah Law Review Symposium on the Law and Ethics of Medical Research. My name is Tammy Frisby, and I'm a third-year law student at the S.J. Quinney College of Law. I'm also this year's Executive Symposium Editor for the Utah Law Review. For those of you who have missed the previous panels or would like to share those excellent conversations with others, we will be posting those videos to the S.J. Quinney College of Law YouTube channel. And in fact, last Friday's conversation about privacy and confidentiality issues in medical research data sharing is already posted there for you to view. This afternoon, each of our panelists will bring a different approach to a set of common questions. First, how does medical research and the way we communicate about research and data influence trust in medical research and, more broadly, efforts to protect and improve public health? Second, where has the law failed to protect trust, and how might the law be reformed in order to improve and advance public health? Professor Heather Tanana will lead off our conversation today. Professor Tanana is an assistant professor at the S.J. Quinney College of Law, where she is also a Wallace Stegner Center Fellow. In addition, she works as an associate faculty member at the Johns Hopkins Center for American Indian Health. Professor Tanana is a national expert in legal and public health issues impacting tribal communities, and in recognition of her work related to tribal communities and the pandemic, she was awarded the 2020 Attorney of the Year from the Energy, Natural Resources, and Environmental Law section of the Utah State Bar. Next, we'll hear from Professor Jennifer Wagner, who is the Associate Director of Bioethics at one of the country's leading innovators in healthcare delivery and clinical research, Geisinger Health. She also holds a position as an assistant professor in Geisinger's Center for Translational Bioethics and Healthcare Policy. Holding a J.D. and a Ph.D., her research is multidisciplinary and integrates anthropology, genetics, law, and bioethics. Our third speaker is Professor Wendy Parmet. Professor Parmet is the Matthews Distinguished University Professor of Law and Director of the Center of Health Policy and Law at Northeastern University, where she also holds an appointment as a Professor of Public Policy and Urban Affairs. Professor Parmet is a distinguished expert in many areas, including public health law. For the Q&A portion of our panel, I'm pleased that we're joined by Professor Jeremy Paul. Professor Paul is working on these issues and writing about these issues with Professor Parmet at Northeastern, and he served as Dean of Northeastern University, where Professor Parmet is also a professor. He served as Dean of Northeastern from 2012 to 2018. For the Q&A, please type your questions into the Q&A feature here on Zoom, and I encourage you to do that as the questions occur to you. That will allow your fellow attendees to read those questions and upvote them if they would also like those questions answered during the Q&A. With that, I'll turn things over to our panelists. So Professor Tanana, I'd like to begin with you.
Thank you, Tammy. So, yat everyone. Heather Tanana Yeneshe, Dene Enishle, Shema Bilagana Nele, Ado Shije Kiani. So, as Tammy mentioned, I am a citizen of the Navajo Nation, and I'm really excited to kick off today's panel. This are issues that I'm really passionate about and I care about. And my initial presentation here is going to focus on medical research in tribal communities. So one of the premises as we get going, and I think something that carries across to all of the presentations in this session, is that there's value in research, right? We're going into communities, identifying problems, assessing needs, trying to find a solution to those. I think at the outset, we can all agree with that premise that in most situations, research is intended to promote public health. And Another premise is also that there's value in having diversity in our research. We know that health disparities exist and health inequities exist. So we know that certain populations, certain groups of people are more in need than other groups, that they suffer from different types of health complications and issues. Maybe some underlying epidemiology might be implicated in how we treat those conditions, right? So it's not surprising then that NIH has a requirement with their funding that studies include women and minority. And in fact, if you're listening on this morning's presentation, there was one of the presenters commented that with our COVID studies, there's a concern about lack of diversity in our studies. Right, one example is with the treatment, I think it's warfarin, a blood thinner that's used to reduce the risk of stroke or heart attacks. When it's given in Native American communities, it's often provided in a lesser dose. So having diversity, including women, people of minority in our research study can help make sure that at the end we have a solution, a result that can work in all communities and not just white old men. So with that kind of background and premise in place, I want to flash forward. In September of this year, Pfizer announced that they were going to conduct their phase 3 trial, COVID-19 vaccination trial with Navajo Nation. And hundreds of comments were made on Navajo Nation President's Facebook page when this announced, and the vast majority of them were not positive. Here's a little sampling that you can look at, right? One right here. It's making me think twice about the flu shot. They might switch it out with COVID, so no flu shot for me, right? A lot of common themes here about feeling like they're a guinea pig to be tested on. Please do not trust the government. We're not guinea pigs, right? Again, this underlying current that the government cannot be trusted, and questions about the credibility and the way that the trial will take place. Some of these, if you're not familiar or used to having worked with tribal communities, right, maybe surprising, right? Can someone really, do they truly believe that they won't be given a flu shot, that instead they'll be given a vaccination without knowing at all, without any consent in that process, right? Some of us, that may seem kind of crazy or not really a valid concern. But if we look at the history of medical research in Indian country, if we look at the past policies that our federal government has had with these communities, we're going to see that these concerns are not way far off based. And in fact, I'm going to say they're very legitimate. So I want to go through and provide just a brief snapshot of that history. This is not all inclusive, right? But I want to hit a few key points to give people a bigger background who may not have it, right? So coming up with Thanksgiving, a lot of people celebrate this. A lot of Native people do not, right? When the Europeans came over to the Americas, a lot of Native American communities were eradicated. And in fact, during the French and Indian War, right, we know that British military commanders actually advised and ordered that infected blankets be distributed among American Indian communities as a means to eradicate the race. Half of the Cherokee Nation, 2/3 of Omahas were eliminated, and the spread of infectious diseases was quite rampant among Native people in this country. And in fact, body parts were collected from the battlefields and from hospitals of Native people to be further studied upon. Right? We're going to flash forward just a little bit at the end of 1800s, beginning of 1900s. Trachoma, an infectious eye disease, was a really serious health problem. And it was being treated in different ways until until a sulfa drug was discovered in the 1930s. But prior to that point, doctors routinely performed tarsectomies on Native people. And that's a very serious surgery, removing the upper and lower eyelids. And they did it to men, women, and children. And they did it without really checking to see if it was a successful means of treatment, without really obtaining any sort of consent from the patients, right? 50s, the Air Force wanted to do a study about the thyroid gland's role in human acclimatization to cold weather. So they decided, let's do this on Alaska Natives. Again, men, women, children, elders, no regard to what, excluding pregnant women or young children. They had this community ingest radioactive isotopic dose in a dosage that exceeded the then current recommended dosage limits, which are, even more excessive than today's limit. And again, concerns about the lack of any sort of informed consent without the community really understanding what they were taking, what the implications of that could be. 1970s, Native women were sterilized without, again, knowing that was happening, giving their informed consent. You go into the hospital to have a child, you come away, and you can't have any more children. And anytime I talk about this history, I do get emotional. And that's another principle that we have with our Indigenous people, that the community identity is so strong that something that happened to another member of my tribe, an ancestor, or even another tribe, often feels like it happened to you. So I just do. Anyone who's heard me, I get emotional on these things. I want to end with the Havasupai Study. That is your textbook case about a Native ethics case gone wrong, where Arizona State University came into Havasupai. They had very high diabetes rates, and Arizona State said, let us help. Let us come in, we'll study this, and we'll try and find a solution, some kind of treatment that will work for the tribe's benefit. Blood samples were collected. In the end, they couldn't find kind of a genetic link to the high rates of diabetes. But then those blood samples were then used by other researchers to study and analyze issues that the tribe and participants had not consented to and did not know were going to happen. And they were studies that were very offensive and conflicted to the traditional teachings of the Havasupai, looking at schizophrenia, inbreeding, migration study patterns, just really alarming that would happen. Come in to do one study, and then all of a sudden a whole myriad of other issues are used and analyzed. And that resulted in a 2004 lawsuit. ASU was banished from the reservation for quite a period of time, and the lawsuit was eventually settled out. So even beyond these research and research-related events, there's a whole series of other past federal actions that have happened in this country that have resulted in harm to communities and mistrust that continues today, right? And so what I was briefly mentioning on that last slide, this concept of historical trauma wasn't just, right, the colonization, the mass genocide of Native people in this country when the United States before it was even established, right? Beyond that, we have our boarding school eras, the separation of children from their families, really, kill the Indian to save the man. You hear a lot of those things. Again, these were actions that were done by the federal government. There were policies enacted by the federal government. And this is rooted in a system where the healthcare system of Native people is also rooted in the federal government as a treaty responsibility with our Indian Health Service, Federal Hospital Service, right? So we've got this very complicated relationship and history that is just filled with actions that were not for the best interests of Native people and very naturally resulted in mistrust that continues to exist today. Now, a lot of those are there are these very common experiences between tribes, but I do want to emphasize that we have 574 federally recognized tribes today that are all distinct and unique in their own ways. They're going to have different cultural teachings. They're going to have their own language and origination stories. So overall, right, our takeaway is American, Indian, Alaska Native people in this country, they have a past that we cannot ignore. And it's a past that continues to haunt us today. And we need to take that into account when you're working with a tribal community, when we're wanting to promote, even when it's well-intentioned and we want to help that community. So overall, based on these events, right, our general issues and challenges we've encountered: lack of informed consent, failure to really evaluate the risks and benefits of that, right? In our eye case, sometimes not even pursuing the most effective treatment, doing what's easiest or cheapest, which results in placing individuals at harm and taking care. So in the couple, I want to make sure we have plenty of time for the other panelists and question and answers. So my last minute or two here, I want to return back to Navajo Nation and COVID-19. We've seen, right, CDC came out with a report a couple months ago that Native people are disproportionately impacted, right? We also know other minority groups are disproportionately impacted by COVID-19. And early on, Navajo Nation was one of the tribal communities that had extremely high rates. They entered some serious lockdown orders, mask orders. The numbers dropped, but like everywhere in the country, the numbers are on the rise again, and they have just entered a 3-week lockdown period. So here's a community that's being, very seriously impacted by coronavirus. They have underlying conditions that can make it more serious outcomes. When they catch coronavirus, more likely to result in a death. There are other infrastructure challenges. So we think, Navajo could benefit from the vaccine, right? And a lot of people, I think, were excited when the Pfizer's trial was announced. But I want to go back to those Facebook comments. Why was there this initial pushback to participate in the study? And I think it comes down to kind of really 3 things, right? One, there's still an underlying concern about the safety of participating in a trial. Is it going to benefit that individual, right? A lot of the community members felt like it was still experimental. Come back to us once it's fully proven. The other one I'm going to emphasize is the money, right? Participants, it was being advertised that you would get close to $800 for participating. That can be a lot of money to someone. And in particularly during the pandemic, when we've had loss of jobs, a lot of people relied on tourism, that money could be a real sway to lure people in who might otherwise not really have wanted to participate, right? Again, we're dealing with often small communities. What's the privacy of people? If you go into the clinic to get the shot, probably going to be recognized by someone. So concerns about, are we really going to protect the identity of the individual? A lot of stigmas associated with COVID right now. And then again, this big one, right? What's our cultural and tribal integrity? Blood samples are being taken. What's going to happen to that? That's a big issue with Native communities about removing a piece of yourself. Where is that going to go? Real unique kind of concerns that we want to make sure are being taken. So I'm scanning through these real quick. You can look at the slides later or ask questions because I want us to get over. But overall, right, what I want you to come away with is that the history with Native people is so important. You have to educate yourselves about it. And based on that, it's not surprising that there was a lot of backlash and pushback about the COVID-19 trials. I think that the principal investigators tried to do their best they held some town halls, right, online. We can't meet in person. There's an infrastructure problem where internet is not widely available to the community. How can we meaningfully participate online and remotely if you're lacking cell phone service, if you don't have a landline, right? So I think they had some challenges there. And again, the people felt like they were being bribed, that an elder who otherwise would not want to participate was being essentially bribed too, because how could you turn down $700? And then the last one I'm going to say is the lack of Native-led research is also an underlying issue. Love Hopkins Center for American Indian Health. They have a good relationship with Navajo Nation, but the PIs are not Native. And so again, you have this lack of trust, it can be easier to overcome that when the projects are initiated from within the community and community-led. Okay, so that I will leave there and look forward to the other two and questions.
Thank you so much, Professor Tanana, for sharing those comments. And when we get to the Q&A, I hope that we can talk more about informed consent in Native communities, because your comments about both respect for the historical experience and for the emotional resonance make me wonder how we can actually engage in truly informed consent with Native communities. And I actually expect that our next speaker, Professor Wagner and Professor Parmet, will be building on these notions of informed consent and the research process. So thank you very much for your comments, Professor Tanana. Professor Wagner, to you.
Great, thank you. It's a pleasure to be here. Thanks for giving me the opportunity to be part of this panel. And that's a tough act to follow from Professor Tanana. So I'm going to take us in a different direction a little bit. And I have no slides today, which is atypical for me, but I was hoping that the internet would cooperate with me coming from rural central Pennsylvania. I'm going to talk about minding the data, not mining the data, but minding the data, and how the COVID-19 pandemic has influenced or potentially could be influencing larger data protection policy discussions. And so this starts with a recognition that in the United States, and my talk will focus on the United States, there are data silos and governance of data is highly compartmentalized in a sector-specific way based upon where the data originate, as Kate Spector-Baghdadi discussed on the first day of the symposium. But healthcare and public health enterprises have intentionally been breaking down or trying to transcend these boundaries for the past few years with precision medicine and precision public health. So the idea that we want to make as much use of the data that are available as possible, we want to better capture social determinants of health and allow us, hopefully, to make more accurate insights about human health and disease. And this march towards anticipatory medicine, as opposed to reactive medicine, at least in theory, brings healthcare and public health in closer alignment with one another with this preventative focus. So we've also seen this move towards precision health, big data, AI, and implementation of learning healthcare system as prompting conversations about diversity and inclusion, and having research cohorts as well as research data sets be representative. And that was covered quite nicely in the preceding talk. In public health settings, it's been less about having representative participation and more about universal participation, with the idea that exceptions and opting out could potentially undermine or the impact that that public health intervention might have. And so when we think about COVID-19, it's this really interesting setting where precision medicine and precision public health have in theory collided, right? So the Future of Privacy Forum tweeted a couple of days ago, and I'm quoting, "COVID-19 means data collection, analysis, and sharing play a crucial role for organizations racing to advance research to contain, mitigate, and remedy the disease," close quote. And both healthcare and public health professionals have had urgent needs to access data to understand the coronavirus, how it affects humans, how we can rapidly and safely generate treatments that actually work and vaccines that will be safe. And as the pandemic has played out, as Professor Tanana had mentioned as well, we've seen it highlight the ways in which it's exacerbated existing disparities based on racial and ethnic lines, based on sex and gender, and also economic bases. So when we think about participation and data access and use, we also have to take a step back and think about the distinct ethical frameworks that have been at play in the biomedical sphere and the public health sphere, because they haven't always been in lockstep. They have had some distinctions, including the fact that in biomedical contexts, there is a heavy emphasis on respect for autonomy, and the hallmark of precision medicine to date has been an opt-in approach, relying on informed consent, although that's increasingly broad consent. And by contrast, public health ethics emphasizes justice and solidarity, among other principles, and that leads them to different directions, including frequently taking opt-out approaches to those programs. Now, during the first wave of COVID-19, we really saw the scientific community feel this sense of urgency, the need to do something, seeing that nothing was being done or not enough was being done, and that colleagues on the front lines of this infectious disease really didn't have the tools that they needed. And so there was this drive, this interest in leveraging the research infrastructure to try to help in that pandemic response, to assist in any way that we could. So you saw scientists thinking or trying to donate reagents, lab materials and equipment, personal protective equipment. We saw researchers also trying to pivot their projects in order to answer COVID-related questions that fell within scope of their informed consent processes. And the Seattle flu study is an interesting example of that my colleague Meg Dower and I wrote about earlier this year. But leveraging research infrastructure for technically non-research purposes for pandemic response does raise some thorny ethical and legal questions related to who can decide to repurpose the infrastructure in that way, and when, how, to what extent, when does it stop, what's the accountability? Those are all left unanswered. Along with this come these complicated questions about the data themselves, about COVID-19 results, exposure history, and behaviors that you're taking to reduce risk. And that information has been desired not just from the healthcare community and the public health community, but all sectors of society, right? We've seen employers, retailers, landlords be interested in this information, school administrators, even election officials trying to make it safe for us to vote. And this has begun to prompt some conversations that some had been delaying regarding data governance and the need for some reform in data privacy, data protections and privacy in the United States. So in a 1-month period, we saw 3 bills introduced. We saw Senate Bill 3663, the COVID-19 Consumer Data Protections Act of 2020. This was introduced by Senator Wicker and others for, quote, to protect the privacy of consumers' personal health information, proximity data, device data, and geolocation data during the coronavirus public health crisis, close quote. A week later, we saw the Senate Bill 3749 and a House companion, HR 6866, the Public Health Emergency Privacy Act, be introduced. And this is to protect the privacy of health information during a national health emergency, so slightly different angle. And then 2 weeks later, on June 1st, we saw Senate Bill 3861, Exposure Notification Privacy Act. This was introduced by Senator Cantwell and Senator Cassidy. It was a bipartisan bill, and it was to establish privacy requirements for operators of infectious disease exposure notification services. Now, despite the urgency of this deadly pandemic, right, despite the many anticipated ways that COVID-19 related data could be stigmatizing, could be used unreasonably, arbitrarily, perhaps unfairly, to infringe upon an individual's liberties, including access to spaces, the bills went nowhere. They were dead on arrival. They stalled out completely, which was relatively the same fate that we've seen from general data protection and privacy law reforms as well. So last winter or December, we saw a discussion draft of the United States Consumer Data Privacy Act. It was never introduced formally. In December, we saw Senate Bill 2968, the Consumer Online Privacy Act, which would, quote, provide consumers with foundational data privacy rights, create strong oversight mechanisms, and establish meaningful enforcement, close quote. Sounds pretty good. Also went nowhere. And things have been relatively quiet until September, when the Senate held a hearing on the revisiting the need for federal data privacy legislation. And Senate Bill 4626, the Safe Data Act, was introduced again by Senator Wicker to establish data privacy and data security protections. Now, the features that have really been at the core of this negotiating or net legislative impasse have been pretty much the same, whether we're talking about COVID-19 specific legislation or broader general data protections. And those involve the definitional scope. So what information should be protected? How broad do we want to be? In one of the bills introduced by Senator Cantwell and Cassidy, it was all linked and reasonably linkable to an individual or a device. So pretty broad definition of data to be covered. We've also seen a sticking point be whether or not state law should be preempted, including the California Consumer Protection Act that was recently amended by the voters, and also whether there should be a private cause of action. So those are where the dividing lines lie, but they've pretty much all agreed that the entities that should have enforcement oversight responsibilities are the Federal Trade Commission and the state and territorial attorneys general, which happens to be the subject of a new project that I have funded. So I hope to be able to discuss this more and write about this a bit more in the future. But there are other sticking issues, other challenging aspects of this, particularly as it relates to the generation of these data, any kind of data valence, because it does involve these public-private partnerships involving tech giants, right, that not only are increasingly subject to public scrutiny for questionable or unsavory data practices, but also are the focus of other formal inquiries, such as their antitrust investigations. Now, as Jonathan Marks, a colleague of mine, wrote in his recent book, Perils of Partnership, one has to ask how strict policymakers will be, how stringent the enforcement will be, if we have these tight-knit relationships with these private entities and there's no viable public alternative for the infrastructure that really is fueling our modern economy, right? Now, ultimately, what happens in the context of COVID-19 data will likely have influence and ramifications on other contexts. There's usually, sentiment spillover, right? If you lose trust in one area, you'll likely lose trust in another, whether that's justified or not. So take the Apple-Google exposure notification API. That's today, it's 6 months old. It was announced May 20th. And so it's now been available for 6 months. And based on the most recent data I've been able to locate, there still are only 16 states and District of Columbia that have actually created apps and launched apps for the public to use. So the ethics of data valence which there's been a lot of great bioethical scholarship this year, I have to say, on these points, really do cause us to question the duration of the data valence, the urgency of the data valence, and also, is it actually going to make a difference? Will it have a meaningful public benefit? So right now, awareness of these apps is pretty low. Uptake is pretty low. Proper usage is even lower. For example, you can turn off the Bluetooth feature that will enable exposure notifications. If people aren't actually using that, is that actually going to curb the spread of the disease? Probably not, in my opinion. And so we do need to think about these technical debts, the ethical debts. We need to think about how these data valence strategies are not only getting implemented, but what's the cutoff point? How long are we going to let them last? Now, I mentioned there's a lot of great scholarship here. My own concerns have actually focused on hypersurveillance of the data rich and hyposurveillance of the data poor, and what that means for growing data disparities and its impact on health disparities, right? So this relates not only to containment of the coronavirus and bringing an end to the pandemic, but also to just regular care and research. So I've already begun, anecdotally, to see attempts for varying opportunities for research based on data wealth. And what do I mean by that? I mean, individuals who have data available. Have you had direct-to-consumer testing from somewhere that you could donate those data or contribute those data to a research effort? Have you been part of other research projects and focusing recruitment efforts on those individuals who have a lot of data? I have concerns about the downstream technological and scientific advancements and what this means for equitable distribution. So the equitable distribution of benefits and burdens of research, as well as the contributions and the opportunities to participate, not only as research participants, but also as researchers, is of tremendous importance. I think we also need to have a harsh reconciliation of the fact that this push towards a more inclusive approach in precision health, in precision public health, is happening in the midst not only of historical trauma, which was discussed in the prior talk, but also in things happening today that very, very intimately affect people's lives and their trust of the government, their trust in data collection, in biospecimen collection, and what's going to happen with data valence. We have a lot of examples that I could mention. I would say we have the administration with its executive orders related to travel bans, rolling back Privacy Act protections. We have the rollback of implicit bias training. We have the rollback of LGBTQ protections under ACA Section 1557. September 11 of this year, Department of Homeland Security announced a major dramatic expansion of biometrics and DNA collection that it expressly said is for identity management. And it's going to use not only immigrants, but also US citizens who are sponsoring those immigrants as the guinea pigs for that technological advancement. And this is data valence, right? When we see that interagency data sharing agreements typically are established with memoranda of understanding, it does shake the confidence of the public, I would say, when you have the highest elected official say, I don't like them, and say, they don't mean anything, right? That calls into question, will the agencies adhere to those terms, or will they try to find some workaround to gain access, which perhaps might be easier if we have these public-private partnerships, including the laboratories that are collecting in the information. I want to say that I think an international human rights perspective and an anthropological, which is to say a holistic perspective, could be useful, could be helpful here. I think we need to recalibrate for data justice, regardless of context, and acknowledge that data valence can be a tool of the oppression, right? COVID-19 testing and related data that is shared across the agency is going to influence people's perception, their trust and willingness to participate, not just in precision health, and get care that they need in times of crisis like this, but also their willingness to cooperate with future precision public health efforts. So the international right to science, the right to health, the right to privacy, the right to non-discrimination, these are all interdependent, they're all interrelated, they're indivisible, and they need not be antagonistic. It does not have to be public health versus privacy, or health versus privacy, or science versus privacy, or all of those versus non-discrimination. And I would argue that by minding the data, by caring about it, thinking about it, giving it the most attention, humanizing it, we might be able to refocus our efforts in concerted ways that will respect, protect, and fulfill these international human rights. And I think that one place to start here would be trying to manage expectations and relationships of ourselves and our relationship with our government and the decision makers in this process. If we're more candid about how science actually works, about healthcare is actually delivered and improved, which relies upon data practices, we might be able to move forward in having them be modernized in a way that actually has public support rather than continuing to work under the status quo, which might not really be of tremendous comfort to the people that we're intending to benefit with this work. And with that, I'll wrap up and look forward to the next talk.
Thank you very much, Professor Wagner. And when we get to the Q&A, I'd like to be sure to come back to the idea of sentiment spillover. And in your discussion about the attempts that went nowhere in Congress to regulate, to govern data more broadly, whether research institutions should have a vested interest in the shape of that data governance more broadly, lest there be some sort of negative spillover, and any thoughts you have about what those lobbying efforts might look like and where our resources should be best focused. Professor Parmet, to you.
Thank you so much. It's a real pleasure to be with you today. Thank you for having. I want to, at the start, acknowledge my co-author and collaborator and colleague, Jeremy Paul. Jeremy and I have been working on different iterations of this project for some time now, and the part that I'm going to talk about today is still very much a work in progress. The paper is not yet written. We didn't put together slides in part because I wanted to sort of emphasize the informal nature and the work in progress nature of the discussion. So since the start of the pandemic, there has been what the WHO has termed an infodemic, an overabundance of misinformation about the pandemic, the causes of the pandemic, its course, its fatality and morbidity, and the possible solutions to it. In our work, we're trying to explore both what makes this infodemic different from misinformation in the past, and the role that law has played in creating that distinction. And also thinking about the impact of what this all means, both for our willingness to trust in biomedical research, but also in the outcomes of that research and in public health initiatives in general. You got to be sure there's always been misinformation, including deliberate misinformation, i.e. lies, about diseases. Snake oil salesmen who hawk false cures and demagogues who hunt for scapegoats have been around for a very long time. But what seems somewhat distinct today, at least in the modern era, is what we're calling, what Jeremy has called aptly, second-level snake oil. Here, the misinformation is not only aimed at getting you to waste your money, it seeks to undermine your very sense of truth or falsity, so that the very idea that we can distinguish somehow between snake oil and effective therapeutics breaks down. This is gaslighting on a grand scale, or to put it somewhat more philosophically, the rise of epistemological nihilism. And with it comes a radical form of subjectivity, where one's own feelings and impressions become the standard for judging not simply what one wants, but rather judging what is. In this atmosphere, scientific authority begins to lose science begins to lose its authority, very much in the same way that religion lost much of its authority during the Enlightenment. And respect for expertise becomes significantly devalued. Now, many explanations have been offered for these developments. Partisanship, polarization, the rise of inequality, resentment about globalization, the current president's pathological lying, and perhaps most importantly, the proliferation of social media. When we're talking about public health, we can also point to, and should point to, as I'll get to more in a moment, the abuses in medical research that have been discussed to date. In our work, though, we want to also look at the role of bioethics and health law. And in so doing, we do not claim that these forces cause the infodemic, or that the rise of radical subjectivity regarding health information. But we do argue that bioethics and health law have unintentionally supported the infodemic and enabled an environment in which it has grown. We also suggest that bioethical principles and legal doctrines that did this developed for important reasons. We do not call for their dismantling, far from it. But we do want to start a conversation about the downside and the incidental effects of our increased prioritization of autonomy and subjectivity in health law and bioethics. The reasons for the privileging of autonomy and the concomitant erosion of authority for public health and science are well known and always worth repeating, right? We could talk about the Nuremberg Trials and what was uncovered about the Nazi experiments. We can talk about the Tuskegee syphilis study and the many other atrocities and misuse of vulnerable populations in biomedical research, including those that Professor Tanana described. We can also point to the women's health movement and its insistence on respect for women's autonomy and agency, and AIDS activists who further enshrined the recognition that patients should have choices and that their political movements should be part of the conversation. For example, around what drugs FDA approves. If many of these forces that eroded respect for expertise and pushed for increasing recognition of patient authority came from the left, and I'm saying this sort of in a gross way, they were joined by forces coming from the other side of the political spectrum that pushed for an increasingly consumerist conception of health. Thus, we have heard increasingly about the virtues of patient choice, both in selecting treatment options, and think here about the movement to deregulate the FDA, open up patient choice. And we've heard and seen a move to increase patient choice in health insurance, as through, for example, health savings accounts, and the strong pushback that happened initially to the ACA. These trends are well reflected in and amplified by our law. Now, time here precludes a full discussion, but I'll just mention a few legal developments and doctrines that we're trying to explore. First, the evolution of the commercial speech doctrine. And I think it's important to remember that once upon a time, commercial speech was not protected speech under the First Amendment, that it could be regulated. And in fact, drug advertisements to consumers did not exist because they could be regulated. The Supreme Court began its shift towards the increasing protection for commercial speech in cases dealing with things like informing women about access to abortion rights, right? And abortion services, and allowing consumers to have more information to make important health choices. And yet over time, this patient-focused, listener-focused approach to commercial speech evolved or devolved, whatever you want to say, to the Supreme Court now having a very much speaker-focused provision, which has really made it very difficult to regulate truthful commercial speech. And so we've ended up now with the proliferation of direct-to-consumer advertising and a wild west of misinformation about health, including ads that pretty much, invite patients to take drugs. And now instead of ask your doctor, click here and the doctor will be there, some doctor somewhere will be there to prescribe the medication. And in that world, of course, enabled by the Supreme Court's change in the commercial speech, patients are now the gatekeepers to their own, prescription drugs. Related to this at the common law level is the erosion of the learned intermediary doctrine, begun, in fact, for public health purposes and cases brought about failure to warn in vaccination and contraceptive cases. And yet again, this is another example of a doctrine whose devolution, whose erosion makes really good sense in the modern era, and yet it is also supporting the idea that it is the patient, not the intermediary, not the physician, who should be the judge of the information the patient has, and at least sort of implicitly the choice about whether or not to take a particular medication. Closely aligned to this is the idea of informed consent. And we've heard about the importance of informed consent already on this panel. And of course, informed consent is exceptionally important. It's, ethics 101 for biomedical ethics. And yet again, informed consent, we would suggest, especially as it comes to be the reasonable patient version of informed consent, implicitly supports the idea that choice is the patient's. And of course, the choice should be the patient's. And yet the question again becomes, does that mean the patient is the judge of the information and the knowledge and the final arbiter of scientific understandings? Finally, I want to turn to the Supreme Court's decision and related cases in NFIB, which inserted a very libertarian choice perspective on health into the Commerce Clause. So now Congress's regulation of commerce, cannot demand that individuals choose to do something. That was followed, of course, by the subsequent repeal of the individual mandate, so that if the ACA survives, and the tea leaf readings from the Supreme Court argument suggests that it will be a law, that no longer requires individuals to do something, but really enshrines choice and option. Relatedly, the decisions by the Supreme Court in Hobby Lobby and the subsequent litigation over the contraceptive mandate, not to mention the Trump administration's conscious regulations, all now are enshrining individual opt-outs for whatever is left of the ACA's requirements. So again, we have a world in which individuals get to choose, their own healthcare, and they get to choose what healthcare and what their obligations are for the healthcare of others. I want to suggest that in some sense, this is somewhat similar to saying, I don't have to wear a mask, I may endanger you, but it's my choice. Thus, we have a health law that, broadly speaking, prioritizes individual choice over individual responsibility to the well-being of others. This has, we suggest, helped to set the table for the infodemic. We have, in effect, trained Americans to believe that they know as much or more than the experts, and that they should make the decisions about what's good for their health, even in situations such as mask wearing or vaccination or participating in health insurance, in which their decisions may have significant impacts for the health and well-being of others. Thus, individual choice becomes the final judge of pandemic policy, and appeals to personal responsibility become the most popular response to the pandemic. So where do we go from here? We certainly don't suggest that we should go back to the 1950s and the era when the doctor knows best. And as we have suggested, there are very important reasons, especially protection of the vulnerability, for this move towards informed consent and individual choice. There are good reasons why our law and ethics came to be where they are today. We also believe that health experts need to earn the public's trust. And as we've seen, and as Professor Tanana shows, they have not always earned the trust. But we do think that we need to consider whether our health law has perhaps moved too far into the direction of supporting subjectivity, and that approaches that developed initially to prevent the exploitation of the vulnerable. Again, think about the roots to our bioethics in the Nuremberg Declaration, in the Common Rule, and the revulsion of Tuskegee, that these approaches may have unintentionally evolved to actually reinforce vulnerability. As populations that are the most socially vulnerable are inevitably those which are harmed the most by our descent into public health nihilism. And we have seen this in the COVID-19 pandemic, right? The inability of our population to accept expertise in a wide-scale manner and to accept that their behaviors and their choices should be limited for the well-being of others ends up hurting the very populations that our laws and ethics that were designed to protect choice sought to protect. We thus invite a recalibration of health law and ethics, one that provides a greater accounting for public harms and provides greater weight for expertise. But I will conclude by saying that I'm not quite sure how to get there from here. It's easy. Jeremy and I were saying, it's easy to come up with a great 3-point plan, but we're really talking about a movement of culture and ethics. And at the moment, beginning that conversation, even if we do so in a somewhat provocative manner, seems to be about as good as it can get. So thanks so much.
Thank you very much, Professor Parmet. And before we move to the Q&A, I just want to say that I think the concept of opting out that you raise is so important, and what that means for making people feel like they have autonomy and perhaps increase trust if they think, well, if they're going to let me leave, that must be a good thing. But the problems that can actually produce for trust down the road, I think that that's an underappreciated point about the opt-out feature. So with the Q&A, I'd like to go to the audience questions first. Actually, let's keep with Professor Parmet and Professor Paul. Professor Tenille Brown here at the S.J. Quinney College of Law, who is a national expert in informed consent and related issues, has asked a question about your comments on commercial speech. And she says that your framing of commercial speech as being increasingly speaker-focused rather than listener-focused is so spot on. And what is even more concerning to her, as it applies to health information, is that if the speaker has an ideological purpose for their speech, the speaker gets even more deference to mislead consumers. What do you suggest for those of us living in states like Utah, where there are few private rights of action for consumer protection and where politicians are unlikely to challenge ideological speech that misleads? I mean, recognizing that you said that you certainly aren't holding back a pocket full of answers, is there anything that we can do to fight the infodemic?
A great question, not easy to answer. You know, I've done a fair amount of writing about commercial speech. I think that the doctrine has, as I said, moved in a direction that is not only listener focused, that seems to be increasingly disinterested in fact, right? And one of the things that is particularly troubling, if I'm thinking now about the Supreme Court's NIFLA decision from losing track of years, 2018, I believe, where you get this idea that if the speech touches on an area of controversy, like abortion, even if it's actually factual, right, it is fully protected and the government can't regulate and can't even now compel true factual information. So in that case, California was not able to compel unlicensed crisis pregnancy centers to notify consumers / patients that they were unlicensed because abortion's controversial. It's truthful, right? So, I mean, it's, I think it's very difficult right now to think about this. And one of the things I've been wondering about in commercial speech is whether or not states now really need to move away to some degree from regulating on the basis of speech and disclosure and being more, in a sense, aggressive and regulating actually on the speech, on the basis of content or activity, right? So in NIFLA, again, to give an example, the regulation that California passed was compelled information, letting people know that the unlicensed crisis pregnancy center was unlicensed. But if you're worried about people having their sonograms read by people without any training, the state could prohibit, right, offering sonograms and reading sonograms without training. One might say it is even a violation of Medical Practice Acts, right? Likewise, do we tell people that sugary beverages are dangerous and give them the information, or do we tax them or regulate the sale? So to some extent, the commercial speech doctrine, and this is getting a little bit off from the talk here, but it relates to another paper I've done, I think maybe pushing public health regulation more directly, or at least it's upping the ante and daring the choice. Do we keep regulating by just giving consumers information, or are we going to actually, if we get to the question public health is in danger, do we actually have to start using more mandatory regulations? But as we've seen in the pandemic, there's tremendous resistance to that.
So just one quick thing, if the regulators won't do anything, you got to try consumer boycotts. So if a particular pharmaceutical or some company is lying, make them pay a price for doing that, and then maybe they'll back off a little bit.
Thank you, Professor Parmet and Professor Paul. Another audience question, and I will throw this to both Professor Tanana and Professor Wagner. I'll start with you, Professor Tanana, for comments on this. Your presentations shared examples of reasons for public caution or distrust of the government's actions regarding vaccines and privacy. And you certainly touched on the US's history of treating Native populations, and Professor Wagner talked about the current administration's rollbacks. What would you suggest the government do to remedy this public concern and caution?
Yeah, so it's a work in progress, I'd say, and particularly when we're talking about the federal government and tribes, because again, very unique relationship that's rooted in treaty and statutes. And so the federal government, a lot of that mistrust comes because the federal government has failed to uphold its legal responsibilities to tribal communities, right? Classic example, IHS was created to provide healthcare services. They have been historically chronically underfunded. And so they're not fulfilling that responsibility. So the first one, right, follow your promises. And that's kind of right, the McGirt ruling for those who are more familiar with Indian law. That was kind of a nice shining light that the Supreme Court said, the federal government, you're going to be responsible for upholding your treaty responsibilities, and failure to do so does not excuse it today. So we're getting there. Again, there are consultation policies in place, but what is meaningful consultation? What is meaningful involvement? I think we're improving a little bit, but a lot of work. In the end, for me, I think a lot of this comes down to building the tribal community and government capacity, investing in our youth so that they are the ones who are the PIs, they are the physicians in the community, the educators, and just able to hold the federal government more accountable.
So I would jump in and just say, it's not just about holding government more accountable. We can't just keep saying that and then not vote accordingly, right? We need to hold ourselves more accountable to demand the government that we deserve and the support that we deserve. So I think, I don't want that to be a cop-out response. But I think there's a lot that we could do in terms of recognizing our own empowerment and what we can do. Professor Paul mentioned, boycotts. Yes, that's certainly an option. If we're thinking about, matters of data practices, we can simply stop and not provide the data and not engage. That's easier said than done. But if we are in corporate positions of power where we can control, say, vendor contracts, or we have an influence over employee benefits and things like that, we can demand riders for non-discrimination. We can demand riders for equitable data practices related to those involved in our own spheres. So there are things that we can do short of the need for a law. So I don't want us to feel helpless on that front. I do want to just backtrack for a second to the informed consent question. And Professor Parmet's comment that she doesn't necessarily have all the answers or the 3-point plan to get us where we need to go. Just in terms of this whole idea of informed consent and misinformation and confusion, I think we are seeing, the deception doctrine in the FTC context and UDAPs at the state level, where it's this idea of, if you're not meeting the consumer where they are, if you're not clarifying where they have the misperceptions, where they are confused, that you're actually deceiving them. And I think that might be one angle that we can push on, one pressure point that we can try to get accurate information out there, but certainly not a panacea there, but I think it is an angle. One of the concerns that I have at Geisinger is this whole idea of, the more we base all of our decisions on informed consent, we're asking a lot of that very quick encounter of what does this mean? And particularly if it's broad consent and thinking about all the potential secondary uses of those data, or that they're actually the primary uses, right, in very broad strokes. And I think that we need to call upon our education system we need informed citizenry. So I really do think we need holistic approaches to all of these problems.
If I can just push you a little bit on that point about deceptive practices and broad consent, do you think that the revised common rule and the option of broad consent helps us not deceive subjects, or do you think it makes it easier to just try to avoid being tagged as deceptive?
So I actually don't have a problem with broad consent. I think that we need to emphasize being genuine and truthful in what we're doing. If we don't know all of the facets of the research, I think it's better to say, we want to be able to use your data and your specimens for everything we might think of that might relate to this topic and might relate to health. We actually have unpublished data from Geisinger, our colleague Michelle Meyer and Dan Davis, and some others on this whole issue of what happens when people who have given broad consent for their medical data and their DNA to be used for research have objections to specific projects that come down the line. If there's a disconnect between a participant's view of what health research means and what a researcher's view of health research means, and what an IRB or a research administrator's view of health research means, that's a problem, right? And it's not necessarily saying that the researchers are doing something nefarious or dishonest. It's a disconnect. And we need to have some candid conversations before the research moves forward. And there are, controversies related to the surprise element, right? I mean, I think it's all about managing relationships. And the more we keep the individuals part of that discussion and not really separate the data from the people, I think it makes it easier. The whole idea of de-identified data drives me bonkers, to be honest, because I think it makes it easy for us to think about it as a thing rather than something that is affiliated with a person, however far removed.
Interesting. Could I actually ask you, Professor Tanana, to chime in here with any thoughts you might have about consent in tribal communities? And in particular, do you have any reactions about broad consent? Do you see that as something that is viable in tribal communities?
I think it's a real challenge, right? Because it's not, the focus isn't so much on an individual. It's really, when you're doing research in those communities, you're researching that tribe and their identity. And again, we've had some challenges because some tribes are so small that you can say a tribe located in the Southwest and you give a couple characteristics, everybody knows who that is. And so you've lost that privacy. And, a lot of taboo topics when you're dealing with mental health, schizophrenia, people don't want to be a part of that. And so I think in tribal communities, it's going to be a real challenge to get through on something like that broad consent, right? People will be thinking right back to the Havasupai case. But I think that's just, it's really different. It's very different when you're dealing with a tribe and their characteristics versus going into like an urban center, urban population, and where I think it is more focused on an individual.
Thank you. Well, and to continue on about informed consent and make it timely by throwing in some emergency use authorization, we have a question from the audience about the convergence of these two. They say the panelists have discussed concerns regarding lack of informed consent and complete research into treatments and vaccines. With these concerns in mind, are FDA emergency use authorizations during the pandemic providing adequate protection when allowing tests, treatments, and vaccines to be introduced to the market when products are authorized without having completed the FDA's approval process for safety and efficacy? Do these EAUs essentially extend research into the general public? And I guess I would add to that, from our conversation today, thoughts about what that does to trust. And I'd open that up to any of our panelists.
I guess I'll jump in. I mean, I think it's, we are in a difficult situation here. I don't think there's any question that emergency use authorizations pose a problem for trust. And should a vaccine be authorized that ends up not working, or worse, having significant high rates of side effects. That's a real problem. That is a real problem. On the other hand, we also have to recognize that we have a problem, right? That there's a pandemic right now, that emergency use authorizations were enacted in the first place for precisely the kind of situation we're in, and that there's tremendous risk and loss of trust from not doing something, right? So, it comes, I think, down partly to the deeper problem that we're trying to get at, which is we are a society without much trust right now. We are a society without much trust in our institutions. We're a society without much trust in science, partially for good reasons. Science is an institution, but it's also deeply problematic. And so there are dangers either way you go. I think we all hope that the FDA will be cautious, that they will be transparent. Certainly, we shouldn't get emergency use authorization or go for vaccines based on press releases from companies, for example. That's probably not the way that this should be done. But I want to come back to part of Jennifer's point. When your civic institutions are so strained, it's hard to think of what the perfect solution is right now. But certainly the problems of the pandemic mean, the increasing dramatic morbidity and mortality mean that waiting for the longer regular approval process is not the answer.
And I'll just add to that. I completely agree with the points that Professor Parmet just made. I think this does, I mentioned that the precision medicine and precision public health were colliding here. I think that it does kind of raise the call for, what do we do? Should we have, our medical systems be learning healthcare systems? I think this really emphasized the fact that we don't know what's going to work. We're trying whatever is at our disposal to help provide care. We should be studying that. We have an obligation to study that, to be able to share what's working, what's not working, and not just base it off of, anecdotes from individual providers with their own biases that might go along with that. And so I think that does, we'll have a lot of work to do in hindsight here about the best paths forward. But, getting at those issues of, distrust and not deferring to expertise, I want to pull back for a second to genetic information, because I've been pushing on this for some years, that I thought it was a danger by not returning all information from sequencing or panel tests or the like, and only returning actionable results, because I thought it was giving the misperception to the people that we know more than what we do about genetics. And also it was giving the genetic information more power than what it really deserves in terms of penetrance and expressivity and the like. And so I was arguing, I was in the minority, so it didn't happen this way, right? But I was arguing that I thought we should release the information, all of it, and say, look, we have no idea what this means right now. That's probably going to change, but right now we don't know. We're studying it. We'll continue to study it in the hopes of having people understand that science is messy. Science is messy and it's self-correcting, right? And it's not changing facts. It's the self-correcting mechanism. And I think if there was a better understanding of that, we wouldn't be in this situation. We could rebuild that trust, which would in part give us the ability to make mistakes as we're trying to actually apply this knowledge and help improve care and stop a pandemic.
Can I just add something? I totally agree with all of that, but on another point about emergency use authorizations, which are really not about them, but they're coupling in this instance with PrEP Act immunity. And I do think that there's some good reasons for taking pandemic countermeasures out of the state liability system, but there are some real dangers to doing so. And the danger is that the public is rightfully concerned that there won't be transparency or accountability for anybody should, right, there be problems along the way, be it negligence or gross negligence or whatever. And so by creating total immunity for this and really no system for assuring accountability, no pretty much, how egregious the action, that I think has helped feed the distrust. And so we need to think again about how to incentivize countermeasures for pandemics, which, we need, but also we need to do it in a way that is not corrosive of trust and the public sense that there is accountability, and that should people try to profit or take shortcuts for even, corrupt purposes, that they are not going to get away with it. And that's a concern that I think that has been created by the mechanisms that we put in place.
Thank you very much to all our panelists. I think ending on a point about the importance of accountability for all the lawyers and doctors and researchers that are here today, where we can think about our own roles in the medical research process, how we handle intellectual property, which was the topic of the previous panel, conduct of clinical trials, and how we handle medical research data, that our roles can be to push for change in the laws that Congress passed or the rules that legislators make, but ultimately we all are making decisions every day that affect the law and ethics of medical research and the trust that participants and patients have in that process. So thank you to everyone out there in Zoom land who has joined us today or over the last 2 Fridays. Again, video recordings of all the panels will be up on the S.J. Quinney of Law YouTube channel. And I have to end with just a quick thank you, but so heartfelt, to the fantastic events and webinar and communications teams here at the S.J. Quinney College of Law, Crystal Begley, Spencer Cope, Janelle White, and Melinda Rogers, who just have been a joy to work with and have handled every bobble and smoothed every raw nerve that inevitably happens when you're dealing with technology so beautifully. So thank you very much, everyone. And if you have any further questions about the events, please be in touch with the College of Law, and we will make sure your questions are addressed. Thank you very much, and everyone, please stay safe.